afternoon, everyone, and thank you for joining us for this, the third in the August series of Compass Chambers webinars, looking at legal issues arising as a consequence of the Covid-19 pandemic. Behind the disguise and home haircut, I'm Steve Love, and I'm here with my colleague Elaine Russell. You can find out more about us, if you want to, by visiting the new Compass Chambers website, which Gavin tells me is scheduled to go live next Monday. Elaine called to the bar at the end of May and joined Compass Chambers. In her previous life, she was a solicitor in private practice and has a wealth of experience in conducting complex personal injury litigation involving employers' liability. Adopting the role of modern-day Nostradamuses, we're proposing to look at the impact of the pandemic and issues that might arise in consequence when looking at vicarious liability. And I'll hand you over to Elaine now to tell you about the plan for today's talk.
Afternoon, everybody. Steve and I are aiming to finish the talk in under 25 minutes, so that's the plan. This should leave an opportunity for questions at the end. You can use the chat function, which should be at the bottom of your Zoom window, to ask any questions. And Steve and I will hopefully deal with questions at the end. So in terms of this webinar, we propose to work through the decisions of the Supreme Court in April in the Barclays Bank and Morrison supermarket cases and look at the impact of these decisions and what that impact might have in the post-COVID-19 environment. And the majority of people have been or are still working from home and remotely. Statistics suggest that 71% of UK businesses have furloughed staff. In particular, Steve and I will consider some key issues that might arise between employers, employees, and third-party contractors, and the scope of duties that may arise.
Yes, with more time, we would have looked in a little detail at the developing vicarious liability landscape under reference to the Christian brothers, Mohammed and Cox cases. Lady Hale was on the bench in all of those cases, as well as in the Morrisons case. She delivered the Supreme Court's judgment in Barclays, so her fingerprint is there to be seen on the developing jurisprudence in this area. You'll all be familiar with Lord Phillips' 5 criteria for vicarious liability set out at chapter 35 or paragraph 35 in the Christian Brothers case, which of course was approved by Lord Reed and Cox. But just in case you're not, here's a quick refresher. Firstly, the employer is more likely to have the means to compensate the victim and can be expected to have insured against that liability. Secondly, the tort will have been committed as a result of an activity being taken by the employee on behalf of the employer. Thirdly, the employee's activity is likely to be part of the business activity of the employer. Fourthly, the employer, by employing the employee to carry on the activity, will have created the risk of the tort committed by the employee. And finally, the employee will, to a greater or lesser degree, have been under the control of the employer. In Christian Brothers, Lord Phillips famously declared that the law of vicarious liability was in the move. It was then, but perhaps the brakes have been applied somewhat by the Supreme Court in these recent decisions. So, enough from me. I'll hand you over to Elaine to talk you through the Barclays case.
So I'm going to, the format is I'm going to talk to you about the facts in both of these cases. So both judgments were issued on the same day, which was the 1st of April of this year. And the first case I'm dealing with, Barclays Bank PLC against Various Claimants. It's a judgment by Lady Hale, and she gives an excellent summary on the past case law on vicarious liability. So as Steve said, Lord Phillips in the Christian Brothers case said that there has to be 2 elements present for vicarious liability. The first is that the relationship between 2 people or persons should be a relationship whereby one should pay for the fault of the other. And the second element is that there has to be a connection between that relationship and the wrongdoing. The Barclays case looks at this first point, which is the relationship point. So the facts of this case were that 126 claimants sought damages for sexual assault, and the alleged sexual assaults were of female employees of Barclays Bank by a doctor called Dr. Gordon Bates. So new joiners of Barclays Bank had to pass a medical examination. The alleged assaults took place between 1968 and 1984 and took place in the course of those medical examinations. So what do we know about Dr. Bates? He was a medical practitioner in Newcastle. He was free to refuse to undertake the examinations for Barclays if he chose to do so. He had business on his own account. He did NHS work where he saw NHS patients. And also he did freelance work, including writing for a newspaper column. So he was an independent contractor and he was paid by Barclays Bank per report. He was not paid a retainer by Barclays Bank. And all of the medical examinations took place in his home because he had a consulting room in his home. So the court at first instance in the Barclays case held, and that was in 2017, that Barclays Bank were vicariously liable for any assaults that were proven. And that was the subject of the appeal. So the question for the Supreme Court in the appeal case was, is Barclays Bank vicariously liable for sexual assaults committed by Dr. Bates? So the key consideration for the court was the relationship between the employer and the worker, and what was that connection? And what was said by the court is that in every single case, you have to, and this is what they said, get under the skin of the relationship. So Lady Hale, who's all over these judgments in terms of vicarious liability, she did a brilliant analysis of the recent decisions on vicarious liability. It's a 13-page judgment, and even for me, it's an easy read. So what she said was that the court needs to look at the details of the relationship and understand the relationship. She said that a self-employed contractor could have a relationship within a business that was analogous to an employer and an employee relationship. And if that was the case, then there was vicarious liability. However, in this case, it was held that Barclays were not vicariously liable for Dr. Bates's wrongdoings. And the reason for that was that Dr. Bates's relationship with Barclays Bank was nothing close to an employee. So that's the facts of the case.
Yes, and the decision in the Barclays case is very fact-specific. The Supreme Court accepted that Dr. Bates's role was distinct. It's not saying that there will never be vicarious liability for the acts and omissions of an independent contractor. As ever, it's the lovely phrase that lawyers like, all depends on the circumstances, the factual matrix. The distinction between those carrying on business on their own account and those in a relationship akin to employment might be a little bit more smoke and mirrors than the court was willing to accept. But what if the individual, for example, was only a contractor for the purposes of tax efficiency? So it's going to be important, I think, to investigate, when gathering evidence, factors such as control. And so that's control over the individual, what they're doing, when, where, and in what circumstances. There's a requirement to look at other factors, including management responsibility, payment and how it was made, the extent to which the role being performed relates to the business of the employer or contractor. So is there a sufficient connection? It seems to be the test that the court's looking at here. So what sort of things should employers be careful about and be on the lookout for?
Well, so some of the things that we discussed, Steve and I discussed prior to doing this webinar, was it's so important for employers to have insurance in place for the work that's being done. And that's in terms of that first provision from Lord Phillips. and also for employers and employees to look at the terms and conditions of their contract. Is it a contract for services or for service? And what are they actually being asked to perform? What things are they being asked to perform? And that's an issue with people on furlough at the moment. And Steve and I have had a chat about thinking about the delictual acts of those who have volunteered to assist in furlough and due to COVID. So that's, for example, students and others who have volunteered to assist with the NHS and care homes, which is another topic of a webinar for Compass, and also for charities and those who work with no pay. And something that agents, whether or not you're pursuing a case or defending a case, is you have to, as Lady Hale says, get under the skin of the relationship, I think, Steve.
Yes, trying to identify whether it's a relationship akin to employment. So yes, there's a requirement to fully investigate and examine in detail the circumstances surrounding the relationship. So what about the Morrisons case? It's a very different kettle of fish.
Yes, so the Morrisons case, I think that Lady Hale writes everything, but Lady Hale didn't write the judgment in this one. The Morrisons case, it's William Morrison Supermarket PLC against Various Claimants, 2020, same day, 1st of April 2020, a 20-page judgment, and it looks at two issues. So the first one is vicarious liability, and the second one, which is really important in COVID and the way that we're all performing our duties, is the Data Protection Act 1998. So this was a case arising from the criminal actings of a very disgruntled employee, similar to the Barclays case, in that it looks closely at the relationship between the employer and the employee and the wrongdoing that was committed. So the facts of this case are quite interesting. Andrew Skelton was an employee of Morrisons. He was an internal auditor and had access to all of Morrisons' database, all of their employees' database. So Morrisons at that time employed 126,000 employees, and the access that he had included all of their bank details. So he was disgruntled. So the background of his disgruntlement was that he was running a white powder business through Morrison's mailroom, and actually the white powder was a health supplement. The package burst in the mailroom and panic ensued. So Morrison's discovered what Mr. Skelton was doing. He was disciplined and given a verbal warning. And the court noted that Mr. Skelton harboured an irrational grudge against Morrisons, and the conduct that I'm about to come on to carried out by Mr. Skelton was for the motive to damage Morrisons. So January 2014, Mr. Skelton uploaded 100,000 employees' data onto a personal USB stick, which he had bought himself. He then transferred that data onto 3 CDs. He sent 3 CDs to 3 different newspapers. And most importantly, he uploaded the information onto a publicly accessible file sharing website. He did all of this using a pay-as-you-go mobile phone from his home, and in a particularly nice touch, he had set up an email address using his colleague's name. So within a few hours of Morrisons discovering the data was on the internet, Morrisons went into overdrive and took steps, quite rightly, to remove the data from the internet. The newspapers did nothing with the data that they received. And Morrison spent over £2.26 million in dealing with the aftermath of Mr. Skelton's conduct. But they managed to secure the employees' personal data. So the case itself, 9,000 employees claimed against Morrisons for distress and anxiety that was caused to them. And Morrison's position, unsurprisingly, was that there was no vicarious liability by them, as Mr. Skelton's conduct was with his employment, and there was no close connection between the employment and the conduct. Now, in the Morrison's case, they looked at and actually quoted from another case, which I'm sure lots of people watching will know this case. It's Dubai Aluminium Company Limited against Salam. in 2013. I won't bore you with all of it, but there's a really interesting quote. It says, "The wrongful conduct may be so closely connected with acts that a partner or employee was authorised to do that for the purposes of liability of the employer to third parties, the wrongful conduct may fairly and properly be regarded as done when acting in the ordinary course of the firm's business." So the Supreme Court needed to consider Mr. Skelton's conduct and whether or not it fell under a frolic of his own. And in every court case, certainly recently, you must look at the relationship, conduct and wrong. And the Morrisons case said you have to then look at the connection. So the Supreme Court held that Mr. Skelton was pursuing a personal vendetta and his wrongful conduct was not so closely connected to the acts that he was authorised to do by Morrisons. So ultimately, in this case, Morrisons were not liable, but also, so that's the vicarious liability part of it. The DPA part of it is very interesting. So the Supreme Court looked at, does the Data Protection Act exclude the imposition of vicarious liability? And what they did was they stopped short of finding that vicarious liability can never arise under data protection legislation. And that is very significant with the environment that we're working in at the moment, all of us.
Apologies for that interruption and a telephone call there. That was a chap called Mr. Jeff Clark who was phoning me. I presume he's not logged in there for either that or he was phoning to say what a wonderful webinar.
Maybe
anyway,
Steve, maybe can't hear you.
Obviously you can, so that's a good sign. Again, the decision in the Morrisons case is very fact-specific. The employee carried out an unlawful act while at home and using a mobile phone that he'd purchased personally. It's interesting to see the use of the word frolic, because that's the pre-Christian Brothers and Cox language of Lister and Dubai aluminium when considering vicarious liability cases. And so it may be interesting to see what the consequences of the decisions in Morrisons in particular might be for parties and claims relating to sexual abuse of children. That's a longer discussion for another day, I suspect. But Elaine, there are some unusual consequences of the pandemic for the relationships between employees and employers, and particularly the conduct of employees that might give rise to loss and damage. What sort of things might we be looking at from you sipping your gin and fresh orange?
Well, I've got two drinks next to Steve. This is obviously a vodka and fresh orange, and this is a gin and tonic. I know that this is being recorded, so that's all good. Thank you for that. So, some of the pandemic, I think, employers just don't have the same level of control over their employees, and they can't easily ensure the same standards as they would in an office environment, especially in terms of data protection. So those requirements are probably not being met as stringently at home as they would in the office. And also employees could be using their own unencrypted devices to log on to work servers, failing to lock computers when working from home, or leaving confidential documents lying about. And obviously we both operate in pristine office environments which have been tidied for today's webinar, but certainly you're maybe not as stringent as you would be in a workplace. And the conversations that we have, I think, about privilege matters are taking place in people's homes or in cafes or wherever they are now, to get away from home. And they could be taking place in earshot of household members and also the general public. And also relating to my drinks, the presence of distractions, not usually in the workplace. So people are working different hours, and you know, joking aside, the consumption of alcohol or drugs could actually be involved in somebody's working practices. You know, they could be having a drink and working at the same time. Another thing that I think employees are being overworked, those who are working and maybe fatigued due to staff shortages and furlough, or they're simply unaccustomed to working from home.
Yeah, well, yeah. Sorry.
No, just those types of things, Steve, I had thought were relevant to take into account.
Yeah, well, I mean, there's another consequence of staff shortages, which is that perhaps employees are requiring to carry out work that they're not otherwise trained to carry out, or operating plant and machinery that they're not qualified to operate, or are not being supervised or managed to the extent that perhaps they ought to be. There are issues that arise, I suppose, as well in relation to symptomatic employees, COVID symptomatic employees who, aware of the fact that they're infected, nevertheless continue to work in contravention of government guidelines, and then they infect colleagues, customers, clients and the like, and what's the consequence of that? So I think it's important to consider the steps that employers should be contemplating, given the circumstances that they're facing up to at the moment. I think we've discussed a few of them.
Yeah, we had a chat about, you know, lawyers and agents and everybody advising whether or not employees and our employers, but employers obviously have to perform due diligence when people are working from home. So, for example, carry out risk assessments and take actions that historically they might have relied on office managers or managers within their business to supervise. But obviously the requirement to socially distance and work from home makes supervision more problematic. In terms of data, Steve, I think that password protection is very, very important, so that devices that people are working from cannot be accessed inadvertently. And remote training, you know, we've learned how, hopefully, how to do webinars and so forth, but the communication with employees has to be taking place, and employers and employees require to have clear directions about certain things that they're doing from home.
Yes, about providing remote training about data protection, for example, and clear directions about use of headphones or seeking separate workspace, particularly for sensitive calls, shredding documents, a shredder in the background, and the provision of and use of privacy screens, thinking about what the employer should be providing as appropriate work equipment to allow their employees to work at home and comply with the same regime of regulations and rules that they would have required to comply with in the workplace. And equally, being able to demonstrate that that training and instruction has been given by having employees sign up to agreements regarding compliance with data security guidelines. And just great care to be taken by HR and management, and making sure that everything is as under control as it can be, despite the fact that staff are working remotely. They're challenging times, and employers are going to have to adapt to, I think, what everyone's calling the new normal. It's clear, I think, that responsibility lies with employers to risk assess. I think that's without doubt. Anything else?
I think that risk assess, but also contracts of employment. But I also think for viewers watching this today, is when people come to you for advice, you know, you want to try and get really under the skin of what employers have put in place. And I think the Morrisons case, I think that it was of relevance that Morrisons spent £2.26 million immediately, and I think that went down very well with the court. They did everything in their power to make sure that the actings of one of their employees was dealt with to protect other employees. So. It is challenging times, and obviously everybody has to adapt to the new normal, but it doesn't take away from the fact that there are legal requirements that have to be adhered to, by employers, and they need to take steps. And if they've not got measures in place, then they need to start thinking about putting those measures in place, or else we're going to have lots of other vicarious liability judgments to talk about.
So risk assess and communicate expectations to staff. And if you do that, it seems fairly clear from what Lord Reid said in the Morrisons case, that if they do that, they might reasonably expect to be looked upon favourably by the court. So I think that's all that we had planned to say. We've got some time left for questions. I don't see anything coming up on the chat screen, which is always a good sign that it's been a full and detailed webinar and that we're not being asked anything. If that is the case, I think all it does is for us to say thanks for joining us. I hope that we've provided a useful element of food for thought, if not all the answers that you might have been looking for. If you have any queries, get in touch with Elaine direct, come to me or go to any of the clerks. And of course, and importantly, next week, in the last of our August series, come along and hear what Kay Springham and Ranald McPherson have to say about the care home blame game, whose fault is it anyway? Hopefully we'll see you then. So thank you very much for tuning in, and goodbye.
Thanks everyone, bye-bye.